Hello, everyone. I am Abigail Murat. I am serving as the Training and Capacity Building Coordinator for the New York State Coalition Against Domestic Violence. I would like to welcome everyone to this webinar on best practices for confidentiality in documentation and responding to information requests. Before we start the webinar, I would like to go over some housekeeping items. For any questions and comments that may come up during the presentation, please use the chat box. We will do our best to answer any questions that may come in. Within the chat box, you have the option of sending your questions to just the panelists and or the attendees by changing the to line above your chat box. For access, we will be reading out every question for any folks joining us on the phone. We are recording this webinar. A link of the recording, as well as the materials mentioned, and a copy of the presentation will be made available after the presentation. A link to the presentation slides can be found in the chat box. In order to view the materials, please select Download. We are providing live captioning for today's webinar. To turn on captioning, you can click the CC button in your toolbar and the captions will appear in the presentation window. And now I would like to introduce the Director of Prevention, Lorian Castell.
Thank you so much, Abigail. And thank you for taking us through all of those logistics. Good afternoon, everyone. I'd like to add to Abigail's welcome by extending my own welcome to you and to thank you all for being able to join us today. It really feels like our work to understand the ins and outs of confidentiality really never ends when we're thinking about protecting survivor information, how to resist requests from third parties. We've been talking about this, since we began, and we're really very fortunate today to have Alicia Aiken here with us to offer her vast expertise on this subject. And I'm going to introduce Alicia. I also want to introduce Joan Gerhardt, who will be joining us, our public policy director here at NYSCADV, and she'll be sharing some very New York specific information, particularly around the new DV Advocates Privilege Bill and some of what that means for us. I do want to just mention Alicia Aiken's bio is readily available for you to view. She's the principal at the Danu Center for Strategic Advocacy and the director of the Confidentiality Institute at the same center. But her experience in the field supporting a wide range of organizations on a variety of issues can be seen. If you take a look at her bio, I really want to focus on how much she's contributed to this conversation. Anyone who knows her or knows of her knows that she's been really instrumental in forwarding the discussion on survivor confidentiality. She works closely with NNEDV and always has, and all of the coalitions on this issue in terms of confidentiality, but also on really understanding the legal issues and the sort of the subtleties of where the legalities around confidentiality and privilege and the difference between the two come in. She is the main architect behind many of the tools that we all use, and we're very, very grateful to her for that, like our informed consent and release forms, so much more. So she's also, I wanted to prepare you that she's been given some of the questions that several of you have forwarded that you are looking forward to having answered in this webinar. And given the time that we have, Alicia is going to do the best that she can to make sure that all of that is addressed. It's a very comprehensive presentation. Anything that we're not able to get to, please know that we have a plan for making sure that you will have some of that information in follow-up, in ongoing technical assistance. So the team is really ready to provide you with all of that. So without further ado, I just want to hand it over to Alicia, and just to say that, her contributions to the discourse around confidentiality have not, we cannot overstate them. We're so very fortunate to have her with us today, and I'm gonna let her rip. So thank you so much, Alicia.
Thank you so much, Lauren. That was such a kind and generous introduction, and the first time anyone has ever called me subtle. So thank you, everyone. I'm happy to be here with a fantastic group. I am here today because of NNEDV. They are supporting my ability to do this training today, and they are doing that through their OVW grant, and we are grateful and appreciative of that partnership always, and particularly today. I love that folks are introducing themselves. That's fantastic. I do just want to highlight some of what we'll be talking about today is federal law. Some of what we'll be talking about is best practices that don't necessarily sit in law. And some of what we'll be talking about is about New York. So if you are not in New York, just be aware of that. And then the other thing is most of what we'll be talking about is law and best practices for victim services programs, whether you call yourselves victim advocates or domestic violence counselors. That's where we're focusing on. I can see some folks are coming in who are from other professions, and welcome, fantastic. And I can answer some questions off the top of my head, but when I'm talking about law and best practices today, I am talking about victim services. This is important because there are sometimes distinctions in what is best practice for a mental health provider, for a healthcare provider, for an attorney, or for a victim services provider. So today we're grounding ourselves in victim services. And I think it's fantastic to learn about other professions and how they approach things, because it helps us understand ourselves better if we have a good sense. These are just, you have access to the slides. This is the websites for my organizations. People generally have a pretty good understanding of what Confidentiality Institute does. It's in the name. Danu Center grew out of the number of times that people would call me and say, I have a legal question. And my reaction would be, I actually think you have a relationship strategy power question, not a legal question. And let's talk about your relationships and your strategy and how you navigate power. And the Danu Center grew out of that. That's really, the Danu Center works with mission-based organizations to figure out how do you build the world you want to be in, both internally and externally. So our goals for today are, first, just ground ourselves in understanding the law that protects survivor information, especially since New York has a new law, and that's when we'll have our special guest star, Joan Gerhardt, will talk with you about New York's specific law. And then we're going to discuss considerations for survivor-centered documentation. So again, in victim services, how do we think about what we're doing around documenting the services that we provide and the work that we do with survivors? And then I want to help folks think about a process for assessing official demands for information. And official demands is kind of a big, broad category because they can come from a lot of different directions. But I do think there's kind of one set of steps and a process strategy that we can implement no matter which direction it comes from. And I'm going to walk you through that today. And then just sort of discussion and understanding strategies for supporting informed consent. I have tried to build answers to many of the questions that were asked in advance into the webinar, but please use that Q&A. You can also make comments and thoughts in the chat, but we have almost 200 people in the webinar. So if the chat's active, I probably won't see your questions as they come through. I do keep an eye on the chat. But if you want to have a question that you want to get answered, we would like you to put it into the Q&A box because I will, there's a good shot that it'll just float right by me in the chat. But please do ask questions. I would much rather be there with you. Somewhere in the state of New York. My kid lives in Manhattan, my best friend lives in Buffalo, and everything in between. So I would rather be there with you, but this is the world we're in right now. And so when you ask me questions and I I get to connect and engage in a way that is important for learning and understanding. So I always start with the grounding. It's almost like a meditative or a yoga practice for me. We have to start by grounding ourselves in the concepts. Like, what are the things that we care about? What are the things that the laws care about and are trying to protect? And the thing that matters is the privacy. The privacy belongs to the individual. All of us have privacy choices, privacy rights. And especially the survivors that we're working with have an interest in making choices about who knows which information and deciding which risk to take. I want to emphasize that, which risk, right? Because everything all of us do involves some kind of risk. And different people make different choices. I mean, boy, we really have been watching that play out over the last 2 years, right? So different people have different feelings about what is an okay risk and what's a not okay risk. And what we definitely know is that when people make their own risk choices, if the bad thing happens, it's easier for them to process and manage and recover from. If it was a thing that they sort of like, I considered that could happen, I made the choice, and then it happened. I might make a different choice in the future, but at least I can kind of own it. So it's incredibly important that we think about the point of all of this, the point of confidentiality and the point of privilege is protecting people's choices about who knows what and which risks are okay. And that's not just secret keeping, that's also disclosures or privacy choices. All the rest of it is solely about protecting that. That's important because I think sometimes we can start to think as professionals, I say we because I'm a lawyer and I'm a confidential and privileged lawyer, we start to think that the protections belong to us and that we're, Wonder Woman because we are keeping secrets for people. And if we take a step back and say, no, these are choices that belong to the people we work with. Those are what matter. And what we're doing is we are being facilitators of other people making choices. So confidentiality is that facilitating other people making choices. I promise that when you share stuff with me in order to get help from me, you are not giving up your choices about what else happens with it. You are not taking any more risk than is absolutely necessary to share with me. Right? Because sharing something with me might feel like a risk because what if I judge you? But confidentiality means that you only have to guess about what I might do or about what the people who work in my victim services unit might do. You don't have to worry, well, what if the lawyer tells her husband and her kids and her neighbors who are also my neighbors, right? You don't have to think about all those things. Privilege is the court rule. So I've been talking in New York for years about, look, it's important to distinguish between confidentiality and privilege because confidentiality is you make a promise not to volunteer information. And domestic violence advocates didn't have privilege in New York. You have it. You now have it. We're going to talk about that. But it's a big moment, right? So both you make a promise not to volunteer, you can enforce that promise in court. So I did a thing I often do. I get so excited when I see my grounding slide. I give my whole spiel before going through my other pictures. But just remember that privacy is an individual making choices. Am I going to go left or am I going to go right? It's not secrets and it's not that there's one obvious thing to do and different people will do different things. And every time we ask somebody to share information, we are demanding that they make a choice. And that requirement that you make a choice can start to feel like a bit of a burden. And I say that because as we're thinking about documentation and we're thinking about negotiating demands, we want to be aware that if the more we set up the world in which we work with people to ask them for things, even if they're allowed to say no, the more of a burden we're creating for them of having to make a choice. If you think about, if anybody's familiar with the psychology research about the cereal aisle, like if you give people 3 cereal choices, they'll make a really nutritional choice. And if you give people the cereal aisle at the grocery store, they will just short circuit and get the sugar bumps. It's not quite that concrete, but you know what I'm getting at, which is that like the more choices you're forced to make, the more you get exhausted. And so while privacy is a choice, we don't want to be asking people to make choices unless it's actually relevant to serving them. So confidentiality is that promise. Here's the important thing about confidentiality is that there's always exceptions. Every profession that promises confidentiality has some exception. It's an exception where either the government has decided that the worker is forced to share information, or an exception where the worker is allowed to choose to share information. So every profession has exceptions to their confidentiality promise. Being transparent with people about what those exceptions are is what it means to practice confidentiality and what it means to protect privacy. So I get itchy whenever someone says, oh, it's confidential, because it's confidential doesn't actually tell me much. It tells me that sometimes you will not volunteer my information, but you have not told me what your exceptions are. And so I haven't really learned much by you saying it's confidential. It has to be about discussion. Now, most people don't nerd out about this topic in the way that I do. It was very kind of Lorianne to say that I'm knowledgeable about the subtleties. I think the accurate is that I'm an obsessive nerd about this area. So most survivors that you work with aren't going to have any sense that when their lawyer says it's confidential, and when the child welfare agency says it's confidential, and when their advocate says it's confidential, that those might mean different things. So being a good advocate is being transparent with people. This is what it means here. So that you can make your own choices about how you share with me. So the federal rule, I've taken to calling it the federal rule because what this is a funding requirement that flows from the three primary victim services funding sources: the Violence Against Women Act, the Victim of Crime Act, and the Family Violence Prevention and Services Act. All have essentially the same rule. And again, if you have one of those but not the other ones and you want to have a conversation with me about what's different, I will happily do that. But they all have essentially the same rule. It says if you are a grantee, you shall not disclose personally identifying or individual information about the survivors that work with you, about the people to whom you're providing victim services. That victim services part is important. So if you're in an organization that is also providing batterers intervention, partner abuse intervention, that's not victim services. So that's not covered by this rule. If you keep track of, these are the folks that we're providing victim services to, and it's everybody we're providing victim services to, not just if you have enough money for one advocate to be funded by VOCA, all the people who get victim services have to get this protection. So it's consistent. That makes sense. I think pretty much every victim services program on this call probably either does get this money or would like to. So you want to set yourself up to follow this rule, right? And this is we don't disclose, we don't volunteer information. The exception, because I told you always have them, the exception is if there is a statute that requires you to share, a statute that requires you to share, or a valid court mandate that requires you to share. So in the past in New York, this was the issue, is that a court could legally order you to share information, but you would make it a little hard, right? You wouldn't volunteer it. If a lawyer demanded it, you would say, you're gonna have to take me to court to get this. And when you got to court, you would argue to the judge and say, Your Honor, don't do this. VAWA, VOCA, FIPSA, policy, privacy. And some judges would say, I agree, don't disclose it. And other judges would say, nope, I don't care, you have to. Privilege changes that. We'll get to it in a minute. The other thing that's important to remember about this rule is that survivors can always instruct you to share. And this is a great moment for me to ask you all a question in the chat. Why is it the rule? We have this super strict confidentiality rule. Why is it the rule that a survivor can always instruct you to share information? Use the chat. survivor can always instruct a victim services provider to share information because it's their choice. It's their information. It's their info that belongs to them. Right. It gives them agency, it gives them autonomy. Great. It's fantastic. Look, this isn't the rule across the board. So for instance, mental health providers, if a patient says, I am instructing you to share information, if the mental health provider looks at that information and says, I think disclosing this will do harm, will exacerbate the mental health issue, then a mental health provider is ethically allowed to say, no, I'm not going to disclose it. Right. And so it's important to just recognize that different professions practice differently because you're doing different things. And so remembering that and honoring that is important and valuable. So that shall not disclose includes that you cannot confirm or deny. So you, Vawa Boca Fipsa says you can't confirm that a person is receiving services. You can't confirm that they are still receiving services. If they came to the shelter, maybe police gave them an escort to the shelter on Tuesday, and on Friday, police come by and they say, "Hey, how are they doing?" It can feel weird, and we'll kind of talk about how do we navigate the weirdness. But you would say, I really appreciate how much you care about survivors and all the stuff that you did on Tuesday, and that's not the kind of question I'm allowed to answer. We do have a message board. I can't tell you if anybody, if anyone would get the message, but if you wanted to leave something, I'm happy to post it there, right? You also can't deny that you work with someone. Does anybody use the chat? Why can't you deny that you've worked with someone? You've never heard of the person. And someone says, tell me about your work with Britney Spears, because she's all over the news right now. Yeah, it's like a logic puzzle. The reason you don't deny that you're working with someone is because if the police come to your shelter 10 times and 9 times you say, I can neither confirm nor deny that I've worked with that person, and the 10th time you say, no, we've never worked with them, you have just effectively confirmed that the first 9 were people you worked with, right? So you want to think about it that way. And folks are posting other things like maybe the fact that they haven't worked with you could be used against them, or it might have some harm or consequence. Somebody said it would be a lie. So that's a good point too. And those are all valid, but they're not the lead reason. The lead reason is because if you sometimes say, I can't answer, and sometimes deny, then every time you can say, I can't answer, you're saying yes. So that's just important to track because it can feel tricky sometimes. And I've worked with programs that have gotten a call and they're like, I've never heard of this person. And I'm like, I know, but you have to keep saying, I can't confirm or deny. Okay, so a privilege is the survivor's right to say in court, no, you cannot have it. I don't care how useful it is. And so important to remember, because I hear privilege get talked about as if it's some individual, asserting their will over everyone else's. Privilege is a community level decision that we live in a better world when people have the ability to get help without worrying that the discussions they had when they got help will be used in court. Privilege is a community level decision that our communities are better off when individual people can get help without being forced to share it. So anytime somebody is trying to make an individual person feel bad for exercising privilege, you can choose whether to say it to them or whether to just think it. But it's like our community made this decision that our community is better off. And so this person is actually just participating in protecting the community. Okay. Yeah, Andrea makes a good point that many people get confused because they would say, no, if you say I can't confirm or deny, and they're like, no, I know they're working with you. Don't worry, I don't need you to confirm they're working with you. I know they are. Now tell me more things that I want to know. And that's that can be really tricky. We'll talk when we're talking about negotiating about some other phrases that you might find useful besides I cannot confirm or deny, because that is a very specific phrase, which in some circumstances is incredibly useful, but in some circumstances doesn't feel like it fits well. And so we'll talk about other phrases you can choose. And if you ever get a chance, I'm a podcast junkie, and there is a great podcast, and I can't remember which platform, about the origin of cannot confirm or deny, that it came from a nuclear sub situation during the Cold War. Okay, enough tangents about the Cold War. Joan, would you talk to us about the incredibly exciting domestic violence advocate privilege law that has been passed in New York?
I can, Alicia, thank you so much. And just a reminder, I'm Joan Gerhardt. I'm the Director of Public Policy and Advocacy at NYSCADV. Alicia, I want to go back to your little happy dance earlier, which I loved seeing. We are thrilled that we were able to get the domestic violence advocate privilege legislation signed into law. This is huge news for us. We at NYSCADV, as well as domestic violence advocates across the state, have been advocating for this at least for 3 years, but even prior to when we had an actual draft bill. And many of you who were with us participating in our recent days of action know that this was really a priority for us. So such a great win. And I just want to personally thank everyone who even just sent an email to a legislator to elevate this within all the other pieces of legislation that they review. So just really great news for us. And Alicia certainly made my job a little bit easier by going through that very robust discussion of the differences between confidentiality and privilege. Because we know, as domestic violence advocates in New York State, we have always had confidential conversations with our clients because of the federal provisions. But what we didn't have was what rape crisis counselors in New York State have, which is privilege. So meaning the court could not compel advocates to go to court and provide information about those conversations that we have with clients. And now we do. So that's really wonderful news. Of course, there are some exceptions to our new privilege law, which I will review in a moment. But I do think that it will make it a lot easier for advocates in New York to push back, to quash motions or requests for information by third parties because of some of that, the vague aspect of our statute versus the federal provisions that Alicia referenced earlier. So when we would get, as advocates, a request for information or even a motion to appear, we would throw the kitchen sink at the motion to try to get whoever was asking for the information to understand that the federal confidentiality provisions really did extend to court. But because it wasn't within New York State statute, that privilege, it was always a little vague and really up to the particular court to decide how they viewed the overlay of the federal provisions with whatever the court in New York State was seeking. So now, because we have this privilege enumerated in our own state statute, we think it will make it much easier to push back on requests for client information from advocates in court. Alicia, can you forward for me? So specifically, the new law amends the civil practice law and rules, and that's the statute that governs civil judicial proceedings. So that includes family court, Supreme Court, and a whole host of other civil matters. The statute was not duplicated within the criminal procedure law, which some could view as a difficulty or a challenge. But in New York State statute, within the criminal procedure law, there's an existing statute that essentially applies any rule of evidence within the civil proceedings to criminal court, unless there's a specific statute that says, in this particular case, you can't do that. There is no other statute referencing our privilege for domestic violence advocates. So we believe, just like the rape crisis counselor privilege right now works and is implemented in the field, that this privilege would extend to criminal proceedings as well as civil court. This is something that could at any time be litigated in the future, since it's not specifically contained within the criminal procedure law. But we do believe our interpretation is that it does apply to both based on standing statute. And certainly if there is any litigation on this distinct point, we'll let you all know. We have received a few questions about who the privilege extends to. And the way the law is written, it extends to individuals who are working under the supervision and direction of licensed programs. So programs that are licensed in New York State by OCFS, it could be a residential or a non-residential program. And the individual advocate needs to be up to date on any training standards that are already in the regs for domestic violence advocates. So I really want to stress this point that the new law does not require any new training for domestic violence advocates. So it's a little different than the rape crisis counselor statute when that was implemented. It only requires advocates to be up to date on existing training requirements. Alicia, next slide. So I did mention a few exceptions to our privilege law. Certainly, if a survivor provides an advocate with an informed, written, and reasonably time-limited consent, then the advocate can share that information in court. If the communication reveals an intent to commit a crime or a harmful act, or if the communication reveals a case of suspected child abuse or maltreatment, then the court could compel an advocate to provide information about those conversations in court. So there's a very specific carve out for those types of conversations, an intent to commit a crime or a harmful act, or something that could reveal suspected child abuse or maltreatment. Now, on that latter point, many of you likely are aware that domestic violence advocates are mandatory reporters in New York State when they receive information about suspected child abuse and maltreatment. And the new advocate privilege law does not change that. So we are still mandatory reporters. This now, because of the carve out in the advocate privilege law, goes one step further to say if an advocate has a conversation with a survivor that discloses suspected child abuse, they can be called into court to provide information about that conversation. And the fourth exception is if a survivor institutes charges against a domestic violence program or an advocate that specifically relates to the conversations between the advocate or the advocate of a program and that survivor. So those are the four exceptions to privilege. They're very specific in the new law. But I think overall, we will find that this is a huge benefit, not only to advocates, of course, but certainly to survivors or disclosing, what they want to keep private, right? Privacy versus confidentiality and privilege. So I'm going to stop there. I do see some comments in the chat. I think I'll take a moment to review those and allow Alicia to continue, and we can always come back to this during the Q&A, or I will respond in the chat. But I did also want to let everyone know that NYSCADV and OCFS are collaborating on educating not only the advocacy community in New York State, but our systems partners about the new law, because we really want our systems partners to understand when they can ask us to disclose and when they cannot under the new law. So we at NYSCADV are planning a listening session with advocates in New York next week on October 5th. We have circulated the registration information for that. We can certainly do that again on our listserv, but we're hoping to have a discussion about what education you all see and would recommend for our systems partners to help the implementation of this new law out in the field. So with that, I think, Alicia, I'll turn it back to you.
Thank you
Thank
so much, Joan. And yeah, and I can't emphasize enough sort of staying in conversation and being prepared to protect this, and not assuming that if someone powerful, judge, lawyer, police, prosecutor, seeks information from you, don't assume that they know this law and that they have concluded there's an exception. What we see over the last 20 years, if you look across the country, a state will pass a privilege statute for advocates, and usually within about 2 years, there is a state Supreme Court decision that reinforces the rule. And the reason that happens is because on the ground, people didn't get the message. And so they tried to challenge it, and advocates said, no, we have a rule, it protects us. And the people on the ground said, that can't be right. And somebody appealed it. And then kind of without fail, the Supreme Court of the state gives a great decision because these statutes are clearly written. It just takes a while to change the culture. But if you don't do it, then the culture won't change. So, and we are here to provide technical assistance, and sometimes we can help folks find pro bono attorneys either at the trial level or at the appellate level.
Alicia, just real quick for those who are on the phone, I'd like to just read out a couple of the comments and questions we have.
Sure.
Lauren Castell said, regarding what Joan presented, please stay in conversation with us if you encounter any challenges in your community as you educate your systems on the new privilege law, whether it's in family court or criminal court by extension, so that we can stay apprised of any issues with implementation. Alicia, you said, and reach out to the Confidentiality Institute for TA if you need it. We help programs all over the country navigate challenges to their privilege, and sometimes can help them find pro bono attorneys to handle the court matters, which is what you were talking about. Carol asked if we can have a copy of the New York State DV Advocate Privilege Law that's being presented. Dolores followed that up with where can we find it?
Yes, I will post the public access to the new law, a link to that in the chat as soon as Alicia takes over.
And Alicia, we also just had someone ask if the PowerPoint presentation will be available.
And I believe you all had a plan for how people should download that, but I didn't recall what it was.
Okay. We will address that.
Okay, thanks. Okay, so let's talk about documentation, because I think now is a really good time to talk about best documentation practices, because now your records are more protected than they used to be. And I think in the past, a lot of thinking about documentation was deeply defensive. And I don't think that should entirely go away, but I think it's a good moment to kind of refresh and be like, okay, like, let's make some decisions about what is best practices. What I'm going to tell you about documentation is there very little that is like a rule. And there's, and where there are rules, they tend to be maybe in funding contracts or agreements. And so you're going to have to pay attention to what applies to your agency as a rule. What I want to talk about today is what are best practices, and best practices means what are the questions that we want to ask ourselves as we are making these decisions. So when we think about documentation, we want to think about that in 3 different stages. I mean, the calls I get tend to be the give stage. Somebody is trying to make us give stuff, but that 3rd give stage is so much simpler if you have been really thoughtful at the get stage and the got stage. So what are we going to get from people? What do we even ask of people to give us? How do we support their right to say, I don't want to give that to you, or that doesn't feel relevant to having you help me? How do we decide what to ask of them in the first place, or to suggest that they should share with us? And then after we get it, then we think about, okay, how do we hold on to it? Where do we store it? How do we make choices about what to write down as I'm working with somebody over the long term as an advocate? How do I choose what gets written down and how long that gets kept? And when do we destroy things? It's funny, like the destruction policy is like the hardest part for people right now, because in 2021, we are living in a time of information technology means everything that was ever known to humans can be stored and saved forever, and nothing should ever be lost. It's kind of the cultural moment we're in right now, right? And I do think we're beginning to maybe reassess that. There are times when it is absolutely right and appropriate to destroy things and not hold on to them anymore. Because if you're holding things that you have no use for, your funders have no use for, and the survivors have no use for, then what you are storing is risk with no benefit. And nobody wants to do that. It's just not a good practice. So let's talk about, as just an example of how we might think through the questions. So let's say that you're running a hotline and that someone is calling your hotline, starting with the get. What do you need to know to help me? And the me in this is the survivor who's calling the hotline. Let's say I'm the person, Alicia Aiken, I'm calling the hotline. What do you, the hotline, need to know to help me? So that involves choices like, do we need to know names to help people on the hotline? Generally, hotlines don't feel like they do need to know people's names, there is a value to providing an anonymous space. Do you need to know the number that I'm calling from? So again, technology has made it possible to know where phone numbers are, but do you need to know that to serve the person? And so if you don't need to know it, can you avoid collecting it? And there's lots of programs that are thinking about their digital services to people and setting them up in a way that will actually protect you from getting the caller ID name or the phone number, so that you don't get information that you didn't need to serve people. These are not questions. I can't answer for you the question of what you actually need to serve people, but I'm asking you to ask the question in a very real way, in a way that is about what are the services that we're providing for survivors? What is relevant to providing those services? And I want you to pay attention to, and as much as you can, avoid acting out of fear. So because this work is hard, we have all been on some level traumatized by the work. I was a legal aid lawyer representing people in poverty and domestic violence survivors for 15 years. And if you add on law school, we're really talking about 2 decades. I was traumatized by doing that work. And sometimes it could lead me to act out of fear. So future clients would get a different version of me because I was fearful of a thing that had happened with a past client. That's not best practice. Now, you can learn from having worked with a past client that something went wrong and you're like, in the service to the person, I miss the fact that on a systemic level, I should be collecting something or doing something. We want to rethink that on a systemic level. But there's a difference between a traumatic experience with an individual client and something that suggests that there should be a systemic change to what you do. So really asking these questions, do I need to know stuff? And so that's the get question on the hotline. Then you ask the got question. All right, well, I was doing the hotline. What do we need to keep? Like, what records of any sort do we need to keep to facilitate these services? And some of that is facilitating, what are we keeping to help the survivors? If hotlines are kind of designed to be one-off interactions, then you may not be keeping much in the way of records of what was discussed or what happened, especially if people were entitled to be anonymous with you. You may not be keeping much because the services that you're providing are really not part of an ongoing engagement. But you also want to ask questions, what do we need to keep to be accountable? To be accountable that we're doing the work and that we're doing it well. I think one of the hard questions that programs face, and this is certainly true on hotlines, which is how do we ensure that we're doing good services on the hotline, because we may have a lot of people on the hotline and they might have a variety of experience. And how does the agency, how do the managers know if it's being handled well? So that's a get question, right? What information are managers going to get about what is happening in a call that is appropriate and doesn't interfere with providing services? And then after that, what information will you hold on to, will you record so that your organization can be accountable to survivors, to the community, internally? And then what's the right amount of time to keep it? If you're running a hotline, like how long does it actually make sense to hold on to anything? And then you get into the give question. So if somebody wanted you to share with them your hotline information, the question might be, what would the hotline give of what they held on to help the survivor? What would they give to be accountable to the survivor? And what would they give to follow the law? So when might, for instance, if you are a mandatory reporter, might you be mandated to share information that you learned as part of being on the hotline call? It's so important to think about that question. How long are we keeping things? When should they go away? How long do you need to keep what you recorded about me? And how long do you need to keep it for accountability purposes? And that question might be different. The answer might be different depending on what it is. So the amount of time that you might need to keep the name of someone that you worked with so that you could check conflicts later on when other people come in, or so that you could confirm that you served them if that helped them. Keeping their name is a totally different question from how long might you keep a Post-it note that the midnight shelter advocate wrote to the person taking over in the morning saying, Alicia had a hard night, there were a lot of nightmares, check in with her. That Post-it note to just say we're transitioning, the appropriate amount of time to record to keep that might be a day, whereas the appropriate amount of time to keep the names of people you served might be longer. So I really want you to think about information as not all lumped together. And I see this a lot when people are saying, oh, well, our grants require us to keep information for 7 years or 9 years or 5 years. And when we look at the grant together, often what it says is you have to keep financial information related to the grant for 5, 7, or 9 years. It does not say you have to keep identifiable information about the people you serve, or descriptions of the violence that they experienced, or their safety plans, right? So ask those questions. Is some information different from other information? And if I am leading from serving people, what is the right amount of time to keep these sorts of information? I think this document from the Missouri Coalition is very interesting. I've been sharing it with a lot of people. It's an entire project that the Missouri Coalition Against Domestic and Sexual Violence did on thoughtful documentation. And it is, when you download the materials, this hyperlink should work, but for any reason it doesn't. If you Google Missouri Coalition thoughtful documentation, you'll get to it. It is a full-on assessment for DV programs in Missouri about what makes sense for recording information, how much and how long, and then how do you distinguish different kinds of information. They suggest using different colored paper if you're printing things out. I think it's a really useful guide that comes from your peers in Missouri. And so I highly recommend people reading it. It doesn't mean you have to do exactly what they did, but it's a really great way it's a model for thinking about things. I'm going to talk for a minute about emergency contact forms in shelters. So what we see a lot is shelters will be like, oh, yeah, no, privacy, survivor's choice. We would never volunteer information. Oh, you got to have a release. It has to be the survivor's goal. Oh, yeah, of course we have emergency contact forms. They give us the right to call whoever is listed on that form if the survivor isn't back to the shelter by 10 p.m. So if you are talking to people about when you stay at shelter, if we couldn't reach you, or if you had a crisis, what would you want us to do? And then letting people define what they would want you to do, then they might sign a written set of instructions to you to do that. But if when they are trying to get safe shelter to sleep for the night, you put an emergency contact form in front of them that they must fill out that doesn't really explain what you're going to do with it or when you would use it or how you would use it, you do not have written informed consent to share. So be really careful about emergency contact forms. If you've been doing emergency contact forms for years and no one has ever said no, I am going to say I don't think you're creating an environment where people are allowed to say yeah, or where people are allowed to say no. They should be discussions. If something happened to you, which is different, right? If you're here and you have a crisis, what would you want us to do is a different question from if you're not here and we can't get in contact with us, what would you want us to do? Because plenty of people, the answer is leave it be. If I am not here, it's because I don't want to deal with you anymore. Or because I've gone underground in a way that I know you can't help with, and that's okay, but you need to not know where I am. And I need to not have people looking for me. So being really very, very careful about how you use emergency contact forms. So you might be giving information if you're forced by a statute, such as the child abuse reporting statute. If you were lawfully forced by a court, which now that you have privilege should rarely be the case, if ever. When survivors give you instructions to do so, or when you are sharing non-identifying aggregate information. I think people are fairly comfortable with this concept now, non-identifying aggregate information. If you are forced to share information under the federal rule, there's a requirement that you make a reasonable attempt to notify the victim whose information you were forced to disclose, and that you take steps to protect their privacy and safety. So one thing that could mean is safety planning with them. You know, we understand you don't have a choice about the child abuse report, but let's safety plan what comes next. But I also think if you get a subpoena or a court order for information, part of taking steps to protect privacy and safety is your organization challenging that subpoena and challenging your court order. I have a question. Dolores says, please confirm if this applies to special victims as well. I don't know what a special victim is. So if you can tell me what that means, or Joan, if you know what a special victim is. So the VAWA VOCA FIPSA applies to victim services, whether those victim services are domestic violence, dating violence, sexual violence, stalking, or family violence. These federal rules, if your organization is getting the funding, they apply. The privilege rule for sexual assault advocates is different. The privilege rule for sexual assault advocates is in a different place in the statute, but my understanding is it says essentially the same thing. And I'm so grateful to have my colleagues from the New York Coalition here with me, and it looks like you guys are fielding some questions that are New York specific, and I appreciate that. So let's talk about how you navigate official demands for information, right? People want stuff from you. Excuse me. People want information from you and they have power, right? They are in a profession where they have been trained to demand information in a way that causes people to hand it over to them. And they take advantage of that power. Sometimes they don't even realize it. I will tell you, there were plenty of times when I didn't think about the way that I was walking into a room and presenting as a lawyer. And so I would ask for what I wanted and I would get it. And I would say, see, I was entitled to that. And really people were like, oh, if she's a lawyer, I don't think I'm allowed to say no to her. So in victim services, you are in a situation, right, where you're trying to protect the survivor's decision-making about what to share, but you might be the face that judges, lawyers, law enforcement, state officials, child welfare, adult protective services. You're the face that they can see and find. So you're the one that they are going to be asking for information. And so you're the one who has to navigate it. So this is super high level, but even if you can just remember these 3 things, I think it'll help you. First of all, stand firm, know your rules, which is part of why you're here today, why Joan went through the state rule, why I went through the federal rule. Your rules are still your rules, even if somebody in front of you wants you to ignore them. And they might even have good reasons for wanting you to ignore them, but they're still your rules. And so you stand firm, but you also respect the relationship. So in other words, if somebody is coming to you and demanding information from your community, either from allied professionals, or they're not an ally of yours, but they do something that has value in your community, these relationships do matter. And so one of the things that I don't love about the I can neither confirm or deny is it sounds like you are both, you're standing firm for sure, but it sounds like you are rejecting the person. Right? It sounds like you're saying, you can't be trusted. You're the enemy. I'm not telling you anything. And I want us to think about how do we stand firm and respect the relationship at the same time? How do we navigate both of those things? And then we're centering the survivor, right? So it's, I'm a victim services professional. I have a set of rules. You are a community professional who has needs. You have needs, you have rules, you have demands and desires. And I can respect my relationship with you without giving up on my own rules. And my rules tell me that I'm always putting the survivor at the center of the decision-making process, right? So it's holding those things true at the same time. I mean, the good news is that if there's one thing that victim advocates are good at is nuance, holding multiple truths at the same time, seeing that everything in our world isn't binary. It's not you're either with us or against us. That's not the world we live in. That's not the world survivors live in. And you all are in a lot of ways best positioned to see that and navigate that.
Alicia, just real quick, I wanted to read out a couple comments for those who are on the phone. There was a question about how long client files needed to be kept, and based on New York State regulations, client files need to be kept for 6 years, said Joan. Wendy asked if this applies to both residential and non-residential services. Joan said that privilege extends to advocates of both residential and non-residential programs. And Andra said, I always ask a supervisor too to make sure I followed the rules. We have VAWA releases that are a new process for me.
Terrific. Thank you so much. One of the things I think we can sometimes forget, is that when an official comes to us and makes a demand for information, they're also a person. And even if they are presenting as super stoic or they're presenting as a profession that doesn't deal in emotions, they do. And so they have feelings about their work, their need to complete a task, their interaction with you, their own vicarious trauma in the past about something that's happened to people, their fear about the current situation, their relationship with their boss, like they are managing feelings too. And so if we can remember to bring all those skills that you bring to the table for working with survivors who are having a wide variety of feelings within themselves and between each other, if you can bring that same, like, this is a human and we're also managing the human here, it's actually going to help you to negotiate these things. And this is what I mean by people would call me and say, I have a law question. And I would say, okay, well, here's the law. And they would say, yeah, I told them the law and they don't care because there's two things going on. There's the feelings of the person you're dealing with, and then there's also a power dynamic. We should never forget the reality of the power dynamics in the world that we live in. I'm going to take a question from the Q&A. Well, saw a question. come
Sorry,
up.
Alicia, that was my fault. I will read out the question for you. Just
Thank you.
'cause I was letting them know that we would answer it for them.
Sure.
This person asked, would the shelter be held liable if the survivor met with some injury or harm when the client had an unusual absence and shelter did not try to locate the victim?
Yeah. So, so there's really two things going on. One is, would the shelter be liable is to a certain extent is a conversation you should have with your lawyer for your shelter. But let's talk about the services you're providing. If you're providing domestic violence shelter services to adults, we're not going to talk about if you're providing them to teens, adults and their children, you do not have custody of those adults. You don't possess them. You don't control them. These are voluntary services. I am assuming that most of you all have policies that say when you're here with your children, you are in charge of your children. We are not in charge of your children. So it would not make any sense to me if when an adult who controls themselves, they're not incarcerated in your center, is not in your center, you are not responsible for them not being in your shelter. Right? This is the tricky part. And again, I think this stems from some of our trauma, right? Is that we have been taught to persistently be afraid that any of our clients could be murdered at any moment because it is a possibility and it has happened, I'm guessing, for many people on this call. And for me, a client has been murdered. So that's terrifying. And it can bleed into how we interact with everybody, that we can start to think it's our job to protect or save people. But the truth is, if you're doing victim services, your job is to support and empower people, to support them to exercise autonomy. And sometimes autonomy means they don't want to come back to the shelter that night, or they don't want to deal with you, or they have gone somewhere else, right? And what's scary is sometimes we think, oh, they're being held against their will, and we don't know it. But people get held against their will every day, and you don't know about it. It's just, this is a hard, I understand why you're asking the question, Betty, but I think it's a really important question. I'm so happy that you asked it, because it helps us look into how do we ground ourselves in what we're doing? What is our actual role and our actual job? And survivors are not incarcerated in our programs. We do not have custody or control over them. They're voluntarily there. And when it doesn't work for them, they will voluntarily be away, and they don't have a duty to tell you. But Andrea points out that you might not be liable, but it sure would be crappy if they came to harm, right? And that is a reality of this work, is that we don't know if the people who we work with are going to suffer harm in the future, but it feels like there's a higher chance they are because of the kind of life situation they're experiencing. And so that's a question inside our organizations and with ourselves. How do we manage that fear of ours? We want to be really careful that we are never constricting survivors' lives as a way of managing our own professional vicarious trauma.
Alicia, may I break in for one moment?
Absolutely.
We had some engagement with the panelists from a participant about the difficulties being trauma informed as, you know, advocates within domestic violence shelters in particular, because we have this sort of antiquated system in New York State of per diem, which requires survivors to be in shelter in order to get paid. And I just wanted to address that because I think it is a very difficult question. We at NYSCADV and domestic violence advocates across the state have been working super hard with all of our state partners, OPDV, OCFS, the governor's office, to acknowledge and really rectify this issue that, you know, for 30 years we had a system in place. It was created for a certain purpose when most survivors really were looking to go into emergency shelter. So it certainly made sense back then. But today, in today's world, might not be, well, we know it isn't really supportive of the needs of many survivors. You know, many survivors are not looking to go into emergency shelter. And there's a whole slew of challenges related to the current funding model that we have. We know that New York State is looking at this issue really carefully. This is a big effort to change a system that's been in place for 3 decades. So this is going to take some time. We certainly wouldn't want to implement something that would cause unintended consequences for survivors or for service providers down the road. So we need to be careful and thorough and comprehensive in our evaluation. But I think we are headed to a better place, a place where we can be more survivor-centered and certainly trauma-informed. We're just not quite there yet. So I did want to address that. I didn't want to ignore that very, very valuable, important point. So I'm sorry, Alicia, to interrupt you.
No, it was incredibly helpful, and I'm so grateful for the work you're doing. Systems change is really hard, right? It is very hard to make systems change, and that's what the work that New York is actively engaged in. And I'm so grateful to see it and to be supportive while you're going through it. You know, the system that says you get paid per diem for someone being in a bed and you have to prove they were in the bed, like that's an incentive to try to control whether someone's in the bed, right? It's an incentive because you're trying to keep the doors open. And, you know, I was on the executive management team at Legal Aid. It gets really hard to distinguish between serving clients and keeping the agency running. And those pressures are intense and they are real. And it's why we have these grounding, what is our purpose, what are our ethics conversations, so we can say when we have to make these hard judgment calls like, oh no, we don't know where this person is, we might not, we can't get paid for this bed tonight. Okay, but our purpose in being here is to provide voluntarily services access as people determine that they need it. And if someone is determined that they're not going to take advantage of it tonight, that's just the reality of it. And that is, and not getting paid for the night is sort of a consequence, but it's a consequence we can accept because that's what keeps us on track with our ethics. I also want to lift up what Andra said, which is when I first got into this field, I was worried I would say the wrong thing and they'd end up going back and get harmed. I couldn't live that way. And someone helped me realize that no matter what I say or do, it's not on me. Just like you said, autonomy and teaching skills is the role. And I think that's exactly right, Andra, right? We all, look, we don't get into this work. And I mean, I'm a lawyer, but I'm a helping professional lawyer, and you all are in victim services. You don't get into this work unless you have both a desire to help and just a little bit of a superhero complex, right? And an ego that says, I can fix things. And the flip side of the I can fix things is that if anything goes wrong, it's my fault. So being very aware of that tendency, like what do I actually appropriately have control over, and how do I do my best work in that space? I teach with a really phenomenal clinical social worker named Christina Simmons, and she talks about professional use of self, which is when you're in a situation that always having a sense of who you are as a professional and bringing that to the table and managing your human instincts at the same time. That's kind of what we're talking about. And frankly, this slide about managing feelings is not just about managing feelings of the people who are demanding information, but also your own. Right. So one of the tricky things about being an advocate is there really is no instance where you get to make a judgment call to share information. Under that federal rule, no disclosure, and under your privilege rule, there is really no instance where you get to make a judgment call that it's a good idea to share information. You may think I have information that meets the mandatory reporting standard, so I'm required to share it. That doesn't mean you think it's a good idea necessarily, but you may be required to. And absent those exceptions, you don't share, even if you think it's a good idea. And so those are the feelings you might be having when people are trying to get information from you. You're like, oh, but this seems like a good idea to me. And remembering, but it's not my judgment call. If there are things I know that make me think maybe it is a good idea, I can share those with the survivor in a space of saying, this is your choice. There is a thing that I've experienced or that I know, and I just want to share that with you so you can factor it in to your decision making. Okay.
Alicia, we've got one question in the Q&A portion about how long whether we should let a survivor know how long we can keep a bed open in shelter.
I think
Asking, would it be appropriate to let the survivor know how long they can keep it open?
that seems totally appropriate to me, right? Like, here's what we can offer you. And if you're not here one night, like, kind of here's what we're able to do or not able to do next. Right? Like, I used to have that kind of conversation in legal aid all the time, because I would say, this is your protective order divorce case. And you don't have to pursue this if you don't want to. If you decided to drop this case and cancel it, and if you ever need help again in the future, I want you to call me, but I can't promise you I'll be available to take the case, because my case list might be full. I will talk to you and we'll try to figure out what else is possible, but I can't promise you if you drop the case today and you come back 6 months later that I will be available. And you try to do that in a way that's not threatening them. It's not saying, ha, you better not drop that case, but in a way that's really just sort of like open and honest and transparent and informative. Okay, we're going to I'm going to keep going. We'll take in a minute. We're going to lift up what's in the chat because there's some really great stuff coming across. I would say that one of the things we want to be aware of is when people come to us demanding information, there are assumptions that they make. So confidentiality means keeping secrets from the bad guys. When you say no to me, you are telling me you think I'm a bad guy. People won't say that out loud, but that is a feeling, and we really have to manage that expectation that confidentiality isn't secrets from bad guys. It is choices by survivors. And sometimes those choices are related to bad guys, but sometimes not. It's not that I'm saying no to you. I'm saying I'm not allowed to make this choice. Other times folks are like, no, but what I'm going to do with it is the right thing. I believe in my work. I'm a good professional. Whatever I'm going to do with what I'm asking of you, it will be the right thing. So therefore, it must be lawful for you to share it with me. This is something I observe in prosecutors a fair amount of time. I'm going to do the right thing. So therefore, you have to give it to me. And another one that's been cropping up in my community that's really driving me nuts is that, oh no, violence survivors are too traumatized to understand their own best interest. They can't make their own choices because they've been so traumatized that someone else has to decide for them. These are some assumptions that people make and that we want to be educating people away from as much as we possibly can. So when someone comes to you demanding information, I would say start by validating the person. Ashley just said, wow, but I don't know which thing is the wow. Validate the person, validate the person, whatever that looks like, whatever's appropriate in that moment with that person. People who feel validated are easier to work with. Communicate your rules. So I have a rule that says, I can't share this. I don't make this decision. I can't confirm or deny. I can't answer those kinds of questions. These are all ways you could put it. I can't answer those kinds of questions. The law doesn't let me answer those kinds of questions. I'm not allowed to confirm or deny. We always let survivors make their own choices. Those are some sample phrases that you can learn to use. But communicate that you have a rule, especially in New York where your privilege rule is brand new. Communicate that you have a rule and be prepared to share it with people, right? And then say to them, because a lot of times you will experience this, people saying, no, but you have to because I want it so badly is sometimes what they mean. But, and you can say, look, if there is a rule that says I have to share this information, a rule that is a statutory mandate that says privilege doesn't apply here, please send it to me. Like, I just want to follow the rules. And I think this can be a really effective thing to say. We just want to follow the rules. Can you send me the rule? Because if they can't send you the rule probably doesn't exist. And there are a lot of professions that have been taught, and it's not their fault, but their bosses for a long time have just been saying, oh yeah, you get this stuff. And then they don't see a rule ever. And so they'll say to you, there's a rule, but there actually isn't, or they don't know what it is, or they can't find it. So make them do the work of proving there's an exception. I once talked to a program that was getting a call from the Office of Inspector General for the federal government. They actually have a lot of power. Like, I wasn't sure what they're allowed to do or not do, And so the program said to them, look, we're covered by federal confidentiality law and we're covered by our state privilege. If you have a rule that says we have to share with you because you are the OIG, can we see it? And the OIG said, yeah, no, there's not a rule. I guess you can't share with us. Thank you, we appreciate it. Right? So like just, I was surprised it worked. I thought for sure they'd produce a rule that required sharing and they didn't. So it is totally appropriate to say to people, we are strictly confidential, strictly privileged. We are covered. I will happily send you a copy of my rules. And if you have a rule that says differently, please send it to me. And then the other thing is, before turning over information, if you are a frontline person in your organization, make sure you know who you would consult inside your organization. So these are hard decisions to make alone. I always recommend people talking. In our legal aid program, we had an ethics committee of about 5 people who were senior folks. One of them was a social worker at our agency who would help the lawyers in our agency and the paralegals and the assistants and receptionists. We would help them assess ethical questions. And so they would say, well, I have an ethical question about, whatever, I'm not sure what to do. And then the committee, we always had someone on call. We were a big enough organization we could do that. We always had someone on call. And then if it needed to be, the whole committee would discuss it. And it was a huge benefit to our staff to be able to have a place to talk that out. The other thing that you may want to do as an organization is if you're the executive director and you're like, yeah, I'm the top and I don't know what to do in this situation, reach out for help. You can develop a relationship with your own attorney that you consult. You can reach out for technical assistance from the coalition, from the Confidentiality Institute, from NNEDV. And we can not give you legal advice, but we can help you identify the questions and kind of make sense of what you're looking at. And often there's not a lot of lawyers who have an expertise in this confidentiality for victim services programs. So a lot of times I will provide technical assistance to your lawyer. Because then I can help your lawyer just sort of know which rules they need to be looking at and kind of what the national landscape is for this. I'm going to do one more slide and then we're going to see what's on the chat. But whenever you get an official demand for information, your number one question is, what does the survivor want? Right? Because the thing we're protecting isn't secrets. The thing we're protecting is choices. And a survivor could choose to waive privilege and have something shared. So the number one thing we're trying to find out is, what does the survivor want? And obviously I'm being a touch snarky on this slide when the number 2 question is, find out what the survivor wants. And the number 3 one is, while you're at it, check in to learn the survivor's wishes. I cannot tell you how often in technical assistance, this question was completely not even considered. Because, people have gotten an official demand. And so they're kind of locked in this interaction with the official and they forget that it's actually the survivor that's driving the bus and they need to check in with the survivor. So unless there is a valid court order that prohibits you from checking with the survivor, which is extraordinarily rare, or the hopefully even rarer national security letter that prohibits you from disclosing that the request has come in, very, very rare. Unless it's one of those things, you check in with the survivor to find out what they want. All right, I'm going to take a breath. I'm going to look at the Q&A. So Shashi has, it feels to me like a comment, which is that the best decisions are made with a clear mind and not when stressed from domestic violence, how to overcome it. You know what? I think you might be trying to ask me a question, but I'm not entirely certain what it is. So if you can weigh in again, then that'll help me to answer it. And then someone else asked, who would you recommend contacting if management isn't able or unwilling to provide rules and policies for procedures when requested? Okay, so if you have an internal organizational issue, that there's kind of an internal struggle about how are we going to follow best practices, how are we going to follow the law, I think that's a really tricky question as a frontline staff person. If you have an management that's not really working with you to follow best practices. But I do think it's not that different from the official demands from the outside. Like, have really open conversations about where people are coming from. What are they trying to achieve? What are they worried about? And how do we come to a consensus as an organization? We have been able to come in, Confidentiality Institute, Danu Center, and lead some really transformative conversations within organizations about kind of, where are you at? What are you doing? What's working? Why do we do? I mean, there was a moment in one group where literally one part of the agency said, well, we collect this information because the other part needs it. And the other part was in the room and raised their hand and said, we don't need it and we never use it. And it was like a moment, right? It's like, woo, like fireworks went off when folks realized that they had been making assumptions and not talking to each other. And they began that day, in that moment, working on change in their organization that was grounded in best practices and that was based on talking to each other. So that would be my first thing, is I would say, is have a really open conversation, not like, why are you doing it wrong? But I want to understand, and what are the forces and pressures that you're managing, and how do we kind of understand first and then move forward? I found this great quote. I can't believe I'm this old and I just learned it, but there's a quote from Einstein that says, if I had a minute to save the planet, I would spend 59 minutes figuring out the problem and 1 minute solving it. And I think that is absolutely correct. That it is the time that we spend understanding the problem and really understanding it then allows us to, sometimes the solution seems quite simple after that. Okay. Let's, in the spirit of everybody kind of knowing, we have a lot of great comments in the chat, and I only have 10 minutes left. I want to do both. Yeah, you all are more important than my slides. My slides say what they say, and you're all going to download them and you can look at them. So let's share with each other. Lorian says, Andrea, we have all been there. It's a little bit about redefining what we think of as success and the goals of what that FIPSA is asking for, and to measure really well within our power, and keeping the people we serve safe for all time is not. That's so incredibly important. So often when I do this training, people are saying, oh, we keep people safe. No, you don't, right? No, you don't. You do provide a resource that people may take advantage of for themselves in defining what's next for themselves in their pursuit of safety. But you don't have the power to keep people safe. You create the conditions that people may want to take advantage of for their own definitions of safety. Wendy says, we worry more that when someone is fully engaged with services and goes to work that night, leaving everything behind and does not return, the feeling to make sure everything is okay is stronger. Absolutely, right? And so I do think having conversations with the people we serve where, you know, a little bit of, you can have this conversation that says, you know, if we unexpectedly can't reach you, what would you want us to do? And some people will say nothing. And other people will say, oh, I would want you to call my mother or something, right? And so finding out what people would want, and finding out, you know, conversing with people about where you will be at. So if you don't come back, I want you to know that we're fully confidential and privileged. So we don't share, like, you know, we don't keep you inside. We don't call the police if you don't come back, because we don't know what you want or don't want. So if you want something different, because there are people who have a safety plan in place that is, if I don't check in where I'm supposed to check in, when I'm supposed to check in, you should be worried, right? So this is part of safety planning with people. Now, you may safety plan with somebody and they don't think there's an issue, and they don't come back that night, and it's gonna feel scary, right? So you're going to have internal processes in your organization. How do you support each other for in that traumatic moment, right? Because that can be trauma and it's going to trigger fear. That's a completely normal and appropriate reaction. How do you support and manage that internally? So it's helping people with their safety plans, including what do you want your safety plan to be when you go to work each day? And how do you want us to do or not do things within your safety plan? And then how do we support staff when we just don't know? And I had plenty of court dates where the client just was not there. And the truth is, not a single one of them was a client being kidnapped. Really, a lot of them were clients being like, yeah, I didn't want to deal with you. Or, and I'm not saying I was bad at my job. I'm just saying, sometimes I was the system and the system wasn't helpful. And so they weren't interested. Or they would say I had work and I couldn't skip it. Or they got in a car accident, which didn't have anything to do with their abuser. So I think it's the not knowing that scares us, right? So Andra says, yes, I have to tell clients when they want me to share stuff. I have to share everything and let them make their own decisions, discussing if sharing of everything will help or harm. At Unity House, we are voluntary, so counseling is not mandated. We don't take mandated clients. Everything is voluntary. So it is having conversations, especially like if people are used to being surveilled and you're not going to surveil them, having a conversation about how we are not surveilling you. I don't want you to assume what we're going to do or not do, because I want you to make choices. And so just know that we are extraordinarily private, probably more private than any professional you've ever engaged with. And here's what that means and what that looks like. And then you get to make choices about what you want. Oh, and Ashley said her wow was about the fact that that people were weaponizing trauma into a belief about a person's experience of trauma to say that people can't understand their own best interest. Yeah, it's been a fascinating process. Carol says, I like to learn the survivor's wishes, survivors driving the bus. This is so true. It gives you a better understanding of the survivor's goal and expectations. It really is having conversations, right? Andra says, my old supervisor told me we hold the map and the survivor drives the bus. It's super interesting to me, Andra. I'm having a reaction to the we hold the map. I would feel more comfortable with we give people maps and then they drive the bus. There's something, and it might not be intentional. I have to own up to the fact that I'm an English major, a lawyer, and a public speaker. So like words, I really pay attention to the subtle differences between one word and another word. And so we hold the map. Like my initial reaction to that is like, well, why are you holding the map? Give it to the survivor, they drive the bus. But I think what your supervisor is getting at is that you've got this ability to show people what's possible, and then they're going to choose where to go. Okay. Shasi has a question. What specifically are the records you can deny to provide to the court? So your privilege covers communications and records related to serving people. It's really broad. It's actually broader. The victim services, what's covered by privilege is probably broader than even what's covered by attorney-client privilege. So it's not a pick and choose among the records. It is assumed they're protected. And if somebody else wants to prove a reason why a specific record is not covered by the privilege, let them try to prove it. And then I have another question. How would you recommend handling confidentiality when it has to do with client files and clients knowing information written? So confidentiality is you don't volunteer clients' information to the outside world. If you are a victim services provider, the information that you write in clients' files, they should be able to see it. And if you are not comfortable with them seeing it, you should not be writing it down. Now, if you're a mental health provider, you get to keep psychotherapy notes that are totally separate from the file that are your own impressions. And if you are an attorney, you get to keep your own impressions and notes that are covered by a separate privilege and they belong to you, the attorney. But if you are in victim services, what you write down is really the survivor stuff that's about the survivor. And if you're not comfortable with the survivor seeing it, you shouldn't be writing it down. Can you keep 2 records? So one is that you will never forward per client's wish. No. So ethical best practice is we serve at the pleasure of survivors. That's what victim services is. We serve at the pleasure of survivors. What they give us is theirs. We may record it to facilitate serving them. If they want it, then we would give it to them. We are not going to try to invent distinctions to allow us to hold something back from them. Right? There is no rule that says you can create like a file for publication to the survivor and a file for holding it back. Victim services is a different ethical position. Betty asked a really interesting, important question about how will the privilege bill impact clients receiving child welfare services where the caseworkers are asked to see the clients in the shelter. If one client signs a release, what about the confidentiality of all the others? So this really, the privilege bill doesn't change this at all. Your confidentiality requirements have always been in place. And this is a complicated question. I think that organizations should be negotiating with child welfare about what is the appropriate way. If a survivor says, yes, I'm living at shelter with my children and I'm fine with child welfare meeting with me at the center, where is a location that child welfare can meet with that survivor without other survivors having their identity exposed? And I think this is going to be really specific to the programs that you are in and the facilities that you're in. You have to be having these conversations with child welfare about, hey, these are our rules. These are non-negotiable rules. How are we going to navigate this? If all else fails, I suggest the rule. So I used to go to the Michigan Women's Musical Festival, which was a music festival in the woods, and it was women only, which has become very complicated, right? Or always was, but we weren't seeing it before. But one of the things that they would do is if there was, they hired a company to manage the porta potties, but that company was almost exclusively staffed by men. And so they had to have men come into the space, and they had made a promise to people that men wouldn't be in the space. So one of the ways they handled that is they would, somebody would walk in front of the tractor and shout, "Man in the woods, man in the woods." And it was such a moment of being like, we have a community, the community has rules. We can't follow it in this moment to get something else important done. So we're going to notify you that something's different so you can choose not to be present. So telling survivors, there is some, we have not been able to negotiate this away. So child welfare is coming into the shelter. We want you to know when they're coming, what time they'll be here. You don't have to be here. You don't have to be in the common spaces. You're allowed to be in your room. You get to make your choices about what to do. If you cannot avoid having someone come inside, then really giving people notice so they can make choices to be absent is a way to handle that. Okay, we are at time's up.
We are. Alicia, I just wanted to thank you so much and thank all of the participants. It was a very active chat and Q&A. I know there's some other things in there, but I really don't think we should hold everyone later. So certainly folks can reach out to Alicia. I think you have a slide, right, Alicia, with your information?
I do. And the remaining slides are about basic informed consent practices, which should be familiar to you. This is all resources that you can use. But yes, so there's the slide with my contact information. We are supported and funded to answer TA questions. Please reach out and ask.
And you can always reach out to NYSCADV as well, or if you're not in New York State, reach out to your state's coalition. I'm sure you could get your questions answered. So thank you again. Thank you, Alicia. This was really informative. I think you presented some really great information. And for those in New York who are interested, please remember to register for our listening session on October 5th. Next week, we'll recirculate that registration information to you, and we'll see you again soon.
Thank you so much, everyone.